You are standing in the most powerful city on Earth. The year is roughly 150 BCE. Rome, the Forum. And you are a woman who has just lost everything. Not to war, not to crime, not to poverty, to a wedding. 3 days ago, you were one of the most educated, most capable estate managers in your family's history. This morning, you own the sandals on your feet, nothing else. And the law has a name for what you are now. It will take the rest of this documentary to make you understand how completely that name erased you. Her name was Licinia. She moved fast through the legal quarter, sandals sharp against cold stone, the kind of woman who entered rooms and people stopped talking. Patrician, literate, 26 years old. She had managed her father's wool contracts, his client ledgers, his land on the Via Appia, the kind of work most Roman men couldn't do with twice the years. She stopped in front of a scribe. Her voice was controlled. The estate on the Via Appia, the wool contracts, the client ledger. I need to know what remains in my name. The scribe looked up from his wax tablet. He didn't hesitate. Domina, nothing remains in your name. Nothing can. She was not a slave. She was not accused of any crime. She had simply been married 3 days prior in the traditional Roman form. And that single legal event had done something that no battlefield, no magistrate, no court had ever done to her. It had made her disappear. The legal term the scribe used was Manus. It means, in Latin, simply hand, as in the hand that now owned her. And then the scribe lowered his voice, not out of cruelty, but out of simple professional courtesy, and said the thing that should have been impossible. Your husband may, if he chooses, bring you before the family court. For any reason. He does not require witnesses. In the position of a daughter, that was the legal category Rome had assigned her, not wife, daughter, a child, under absolute authority, with no standing in court, no right to property, and no mechanism of appeal. What you just witnessed was not an anomaly, it was the system working exactly as designed. But here is what the history books almost never tell you. The women this law destroyed most completely were not Rome's slaves or its conquered peoples. They were its most celebrated wives. And the law didn't take anything from them. According to Rome, they never owned it in the first place. The legal mechanism was called Manus marriage, and its roots ran back to the 12 Tables, Rome's earliest codified law dating to around 450 BCE. The 12 Tables established a process called usus. If a wife slept under her husband's roof for one continuous year without being absent for 3 consecutive nights, she automatically fell under his absolute legal authority. The law did not require her consent, it required only her presence. But Manus wasn't only about property, it plugged Licinia into a larger system. Patria potestas, the absolute power of the male head of household. That meant a Roman woman could pass from father to husband without ever existing, legally, as herself. The question isn't just what the law said, the question is what the law assumed. And if that question keeps you awake, subscribe, because we are only getting started. The Roman Forum was not just a marketplace. It was the nervous system of the most sophisticated legal civilization the ancient world had ever produced. Men argued cases here that would shape Western jurisprudence for 2,000 years. And built into the foundation of every one of those arguments was a quiet structural assumption that women were not participants in the law. They were subjects of it, and under Manus, a husband held what Roman jurists called ius vitae natisque, the right of life and death, over his wife. This was not a metaphor, not a rhetorical exaggeration buried in some obscure legal commentary. It was operational authority, recognised by the state, and enforceable through a private institution that required no public oversight whatsoever. It was called the Concilium Domesticum, the family council. A husband could convene it at any time, for any reason, with male relatives serving as judges. He presided, he decided the charges, he executed the verdict. His wife had no right to legal representation, no right to call witnesses, no mechanism of appeal to any Roman court, because Roman courts did not recognise her standing to appear in them. And what offences could trigger this tribunal? Our Cato the Elder, Rome's most celebrated defender of traditional virtue, a man whose words were preserved by the writer Aulus Gellius centuries later, stated plainly, that a husband who caught his wife drinking wine had the legal and ancestral right to end her life. The same right, he specified, as catching her in adultery. Aulus Gellius recorded this, not as a scandal, as a historical fact worth preserving. This was not a failure of Roman civilization. This was Roman civilization functioning with complete internal consistency. The Roman legal mind saw the paterfamilias, the male head of household, as a miniature state. His home was his jurisdiction. His wife, legally his daughter, was his subject. The state didn't need to monitor what happened inside that jurisdiction. It trusted the man in charge. There was one more instrument in this architecture, infamia, legal disgrace, a formal status that could be applied to women who violated household codes, stripping them of whatever threadbare public participation rights they still nominally held. It was the system's insurance policy, a secondary erasure waiting beneath the first in case the primary mechanisms left anything standing. And Licinia understood all of this. That was the particular cruelty of her situation. She moved through the domus, her husband's house, her legal home, the place she had no standing to leave without consequence, with the practiced authority of a woman who had managed estates. She touched objects quietly. The bronze mirror her mother had given her, the wool account tablets she had built from nothing over 5 years, at the correspondence with clients who had trusted her judgment over any man in her father's household. None of it was hers. Her husband, Quintus, was not a violent man. This matters. He was measured, politically connected, and genuinely kind to her in the way that powerful men can afford to be kind to people who cannot challenge them. He invited her to continue managing the household accounts. He called it a privilege. She recognized it immediately for what it was, the system's most elegant instrument. There was no monster to resist. There was only the law, wearing a pleasant face. She asked her personal attendant, a freed woman with no legal standing to help her, a careful question. Could she have escaped Manus if she had spent 3 nights away before the year was complete? The answer came back without hesitation. Yes, at the Trinoctium. 3 nights of documented absence, and the mechanism would have failed. Her father had known this. He had chosen not to use it. How does a legal system erase a person? Not through violence, not through chains, through definition. Roman jurists described women under Manus using a precise legal term, filia loco, in the position of a daughter. This was not a metaphor for reduced status. It was a formal legal category with specific, measurable consequences. She inherited alongside her husband's actual children, which sounds at first like a form of protection, until you understand that in every other legal context, it meant she possessed the standing of a minor, permanently, regardless of age, education, or demonstrable competence. The jurist Gaius, writing in the Institutiones during the 2nd century CE, documents something even more unsettling. He describes tutela mulierum, the guardianship of adult women, a legal institution that extended far beyond Manus marriage and patria potestas both. Even a sui iuris woman, one who had no living father, who stood technically outside any man's household authority, still required a male guardian, a tutor, to conduct significant legal or financial transactions, property transfers, contracts, court appearances. A Roman woman could be free of every specific legal chain and still find herself legally inert, unable to act in the world without a man's formal co-signature on her existence. Rome had built a floor beneath which women could not fall, and a ceiling above which they could not rise, and they had given both structures the same name, protection. Now go back to the opening of this documentary, Licinia standing in the legal quarter, asking what remained in her name. We told you she was seeking an answer. That was not entirely accurate. She already knew. She had known since the morning after her wedding. She went to the legal quarter not to discover the law's cruelty, but to hear it stated aloud by someone with institutional authority, to make it real enough to become something she could work against. What she found there was not hostility, it was indifference. She was not a target of Roman law, she was simply absent from it, not present, in any legally cognizable sense. She was not seeking justice, she was confirming its absence. And there is a difference between those two things that Rome never bothered to record. But the jurists had not closed every door. there was one mechanism still technically accessible. It was slow. It required a man to operate it on her behalf, and she had already identified the man. Licinia had a younger sister, not yet betrothed. Through an intermediary, a male client of her father who owed a debt she could not legally collect herself, she arranged to send a message. The trinoctium could not save her, but it could, if her father could be persuaded, save her sister. The scene was almost quiet. She wrote on a wax tablet at her household desk, the same desk she had used for estate accounts that no longer belonged to her. Every word she wrote would be delivered by a man, attributed to a man, acted upon by a man. But her legal knowledge, her years of experience, her understanding of exactly which pressure point to press, all of it translated into the world through intermediaries who would receive the credit. Her husband found her writing. He read it without alarm. He asked what she was planning, and she told him plainly, because she had learned that transparency was its own form of armour, that a woman who concealed nothing gave a man nothing to discover. He considered for a moment. He said he saw no harm in it. His permission. She had required his permission to attempt to protect her sister from the law that governed her own life. The intermediary returned 2 days later. Licinia's father had already arranged her sister's betrothal. Cum Manu. Again, why would a father do this? Why would any Roman family, knowing exactly what Manus meant, choose it deliberately for their daughters, generation after generation? The answer is not sentiment. It is not tradition for tradition's sake. It is political economy, precise and unsentimental. Under Manus, a wife's inheritance passed entirely to her husband's family upon her death. Her dowry was absorbed, her assets transferred cleanly, legally, permanently. For aristocratic families seeking to cement political alliances, this was not a side effect of the marriage arrangement, it was the point of it. Daughters were instruments of estate transfer. Manus made that transfer legally uncontestable and irreversible, clean as a land deed, final as a funeral. Licinia's father had not failed to protect her, he had used her. The political alliance her marriage secured was worth more to his family's position than any estate she had built for him. The wool contracts, the client ledger, at the decade of competent management, all of it had simply been the accumulation of an asset he always intended to transfer. She had been the most productive investment in his household. Her Manus marriage was the return. Here is where the history becomes genuinely disturbing. The gradual shift towards sine manu marriage without Manus, which became more common in the late Republic, is often presented as evidence of Roman progressivism, of evolving attitudes toward women. The reality is considerably darker. Wealthy fathers began preferring sine manu arrangements, primarily because they did not want their own estates, leaving their bloodline through their daughters. The reform that gave Roman women marginally more legal autonomy was driven not by concern for women, but by men protecting male inheritance lines. And when women in sine manu marriages began to accumulate and control significant property, Rome's legal system responded with immediate, targeted precision. The Lex Vaconia, passed in 169 BCE, barred women from being named primary heirs of the wealthiest citizens' estates. The law restricting women's inheritance arrived directly after women had begun demonstrating what they could do with it. Every time Roman women gained legal ground, Roman law built a new wall. Not because Rome feared women, because Rome feared what women would do with property. There was one more mechanism of correction waiting, one the legal codes did not need to invoke publicly because it operated inside the walls of the household itself. Licinia was about to encounter it directly. The atrium of Quintus's house held 7 men the afternoon the concilium convened. Her father-in-law sat at the centre. Her husband sat to the right, and said almost nothing. The reason given for the gathering, a dispute over estate correspondence, was technically accurate. The marriage contract scroll lay on the table, and Licinia recognised it immediately. She had not seen it since the morning the scribe read its terms to her. The council did not raise its voice. That was what she would remember. The language was measured, formal, and completely final. She had exceeded the scope of her household role, but she had engaged an outside intermediary without authorization. She would not do so again. There was no sentence, no dramatic pronouncement. She was not beaten, not divorced, not disgraced. She was simply returned to correct position, the way you place a misplaced object back on its proper shelf. When the men filed out, Licinia picked up the marriage contract scroll. She read it slowly. In the formal legal language her father's own hand had signed, one line. She passes into the Manus of her husband as a daughter to a father. She set the scroll down. She did not weep. She had known what it said for months, but knowing and seeing it written in her father's handwriting were not the same thing at all. Licinia is a composite. She is built from documented social realities, not a single surviving name. But the women who inspired her reconstruction are real, and their stories survive. Not because Rome honoured them, but because Roman writers found their endings instructive. Valerius Maximus, writing in the 1st century CE, compiled a collection of notable deeds and sayings as a reference manual for Roman orators. In it, he records multiple cases of husbands who convened family councils and ended their wives' lives for offences that included drinking wine, appearing in public without a veil, and adultery. He does not record these cases as warnings, he records them as examples, models of correct Roman household governance. The men in these accounts are praised for their discipline, their commitment to ancestral custom, their understanding of what a well-ordered household required. The women have no names in most of these accounts. They have no quoted words. They do not argue, or plead, or resist in any form the record preserves, and that silence is not accidental. The law said they did not exist as legal persons. The literature agreed. What a non-person says at the moment of her judgment is not worth preserving. Now reconsider the women of the Lex Oppia protest of 195 BCE, the moment recorded by Livy when Roman women entered the streets of the city in a visible, organised public demonstration against a wartime law restricting their access to gold and transport. History tends to present this as evidence of Roman women's remarkable agency. And the women won. The law was repealed. But understand what they were actually fighting for. Not political representation, not property rights, not legal standing. They were fighting for the right to be seen in public with gold on their wrists. The ceiling was so low that visibility itself was the battle. And even that was too much for Cato. He argued before the Senate that women had no right to appear in public at all, that their presence in the streets was an inherent threat to Roman civic order. As he lost that particular argument, but the architecture he was defending never came down. The system evolved. By the 2nd century CE, Manus marriage had effectively disappeared. Tutela mulierum was increasingly relaxed under Augustus and his successors. Women of the Roman elite gradually gained the ability to own property, conduct business, and operate with limited legal independence. Historians point to this evolution as evidence of Rome's capacity for progress. What that framing omits is everything that came before it, and everything that shaped it, the centuries of Manus, the Concilium Domesticum, operating without oversight in 10,000 households whose records do not survive, the Lex Vaconia, arriving precisely when women began demonstrating financial competence, and at the legal reforms that were granted by men who had spent centuries establishing, in law and in literature, that women were not full persons, and who now chose to extend a carefully measured portion of personhood back, on terms they controlled entirely. The legal freedom Roman women eventually gained was real, but it was a concession extracted from a system that had first required centuries to establish that women had nothing to concede from. You can only be granted rights by a system that has already decided it owns them. A woman's hand places a scroll on a table. She does not pick it up again. The scroll sits. The hand withdraws from frame. The 12 Tables, the foundation of Western legal tradition, the ancestor of every European legal code, as the document cited in early American legal scholarship as a model of rational civic order, encoded women's legal erasure in its original text. The tree that became Western law was planted in ground that had been cleared of women first. We inherited Rome's genius for justice. We do not often speak about what that genius was built on. If this documentary unsettled something in you, if you want to keep pulling at the history that has been smoothed over sanitized, and handed to you as civilization. Subscribe. New episodes go live every week, and the next story is already worse than this one. We did not lose these women to time. We lost them to a system that was specifically designed to leave no record of them. The scroll is still on the table, no one ever came back for it.